that speak to that, Your Honor. And when it speaks of Brady, and it cites the Jones v. Medlin, 302 Georgia 555, and a host of other cases. And the last sentence says very clearly, the individual prosecutor has a duty to learn of any favorable evidence known to the others acting on the government's behalf, including the police. What I'm asking, Your Honor, is I very specifically asked, and I didn't just ask for the Hall documents. We're going to get to what I also asked for when it comes to authorization. And I'll explain to you how I came to that. But very, very quickly, Your Honor, if I can just put up a couple of other documents. Did you get that? We can bring up the page 1 of my email from September 11th, which also I believe was attached, 2023. So the first letter was 30 some odd numbers, right? Then we go to if we go to Exhibit 2, the first page, this is actually, we can go to the email, this one right here. Very narrowly pinpointing the specific request, Your Honor. So it's no longer 37, it's 3 or 4 really key items that I contend they're obligated to search for, okay? And what's important, Your Honor, is with respect to my first letter on August 30th, with respect to this email, as I laid out at the last hearing, I got no response, nothing. And I understand that Brady continues, but we're talking about due process. I'm telling you specifically, government, this is what I contend exists, what you have. And the case law shows you should at least ask the agents, ask the participants in the investigation, the people that are in this case, do you have this stuff? So we had the hearing. I took the court's point about Brady, about the parties communicating, and I sent another email. If we can bring up Exhibit 3. And while we're bringing it up, Your Honor, I'll just read it into the record. I followed up at 2 o'clock after the last hearing on Thursday, September 14th, and I specifically said, following up on the direction from the court at today's hearing, although I believe all the materials I've asked already should be disclosed by the government, I'm specifically asking if the government has the letter of invitation. So I didn't just ask for the letter, Mr. Hall, Your Honor. I asked for this letter of invitation because it goes back to what I said about authorization. A letter of invitation from Coffee County inviting people to come there is clearly Brady. And so I sent that email. And the response I get is, we don't have this. We don't know what you're talking about. Can you send us the media reports? So in fact, I do that. And the media reports are from CNN that says Georgia prosecutors have messages showing Trump's team is behind voting system breach. If we can scroll up a bit. Here's the article I cited to them. I sent this to them. And we had no discovery by this point. None. They sent us, they dropped the drive that same day. Okay? Had no materials. I just knew from what I was able to figure out in the public realm existed from these articles that there was a letter of invitation. And in fact, when I looked at the discovery, we can bring up Exhibit 4. These should be the Sullivan-Strickler text messages. If we could scroll down, this is the first page of some documents that we discovered after we got discovery, but we're also involved in the curling litigation. And this is a critical document, Your Honor. This is a text message from Jennifer Jackson from Sullivan-Strickler, but she's really just cutting and pasting a text message from one Kathy Freese, a lawyer who worked for the Trump campaign. And what she says is, most immediately, we were just granted access by written invitation to the Coffee County systems. Spelling mistake there. Yay. Putting details together now with Phil, Preston, Jovan, etc. So this is where I'm getting this letter of invitation. And so when the government said in response to my email, they didn't know what I was talking about, that was troubling. But then when I sent them this article, Mr. Wooten responded again and said, we've reviewed the article and do not have this letter. didn't appear to know that it even existed. That's what they said, and that's as of September 18th, 2023, Your Honor. That date is important. So it's important, Your Honor, because discovery has now started to be produced. And I do get the GBI report. And the GBI report was produced just 2 days ago. But before that, when they said they didn't have this letter, I went out and I actually called witnesses. And I got the letter of invitation myself. It does exist. So I was able to get it and I attached it to my other motions in this case, right? Because I believe it shows that this was authorized. But then I get the GBI report yesterday or 2 days ago, and I start looking at it. I spent all night because it's 20,000 pages long. And I found a 390-page summary of everything they did and found. And what did I find? Number one, if we can bring up Exhibit 6, it shows that this investigation by the GBI has been going on for a year. August 15th of 2022, they have been digging into Coffee County. It goes on. It goes on. And what's troubling to me, Your Honor, is this. If you go through that report in some detail, and as I did, you see on page 277, the GBI, as of August 3rd of 2023, if we can go to the next exhibit. This is the report, Your Honor, that shows that, in fact, if we can scroll down, they had the letter of invitation and they also had the request that preceded it. And there's two critical things from all of these. It's a 5-page report or 4-page report, Your Honor, I can submit for Your Honor review. It was attached to my motion, my reply today. It shows two things. Number one, the request to get into those systems was not from Sidney Powell. That's the first thing. The second thing is they authorized it. And it goes on to analyze that authorization. And what's critical, if we go up again, they had that information as of August 3rd, 2023.
The GBI did.
The GBI did, which arguably, because now the government has it, they're part of the government team, Your Honor. And it demonstrates that as of August 3rd, they knew that, number one, Ms. Powell wasn't involved, and number two, that it was authorized. And that knowledge is imputed to this government team. So when they respond to me, and we'll go on, Exhibit 8 is, another pages from this report, page 345 from that same report, where they go through 10,000 emails that they happen to have of Misty Hampton, 10,000. Of the 10,000, they note 3,000 were between November 1st of 2020 and March 1st of 2021. And they say they found 7 emails of particular interest, Your Honor. What do they all have to deal with? Authorization provided by Misty Hampton and the fact that this individual, Preston Halliburton, submitted some requests to get there. So of 10,000 emails, they find 7, all of which are exculpatory to Ms. Powell, none of which were produced to me. Instead, when I ask for these letters and for this information, I get told by the government, we don't have it. Well, in fact, they did. They did have the letter. They had it the whole time. And what's troubling about it, Your Honor, is not just that when I asked for it, they didn't produce it. What's troubling is they had it before this case was ever presented for indictment in August of 2023. And it shows that this was authorized. And that information couldn't possibly have been presented to the grand jury because the government didn't even know it existed. Now, they don't have an obligation to produce exculpatory material. I understand that before a grand jury, but they certainly have an obligation to produce the truth. And it raises questions. What law were they instructed on about authorization if Misty Hampton's letter authorized this? And it was at the request of somebody other than Ms. Powell. It's Brady, Your Honor, but it goes more. We can go to Exhibit 10. Exhibit 10, Your Honor, is a copy of the contract, which is referenced in this indictment multiple times in every 32, 33, 34, 35, 36, 37, all those counts, they talk about this contract, okay? It's a contract that, number one, has nothing to do with Georgia, but which they're saying all of this stuff in Coffee Counties were acted upon. That's the first thing it shows. But the second thing that it shows, which is equally...
Judge, I'm going to object to publishing things that are not relevant to the motions before the court. I don't think this is the time for
Mr. Rafferty to put up a factual defense of the case. It's not appropriate and it's not relevant. We haven't, first of all, we kind of gave him some leeway. We haven't seen any of these exhibits, but I think it's gone a little bit too far.
Your Honor, the original motion that I filed that they have already responded to had in it what I'm about to talk to. So they have seen this exhibit. It was buried within it. It was the metadata from the contract, which they have been talking about as evidence of her participation in this. And what the metadata that they sent to me, buried in all this discovery, shows is that, in fact, Ms. Powell did not sign the contract. Their own metadata shows that it was signed by Jim Penrose. It was not signed by her.
All right. So in response to the objection, Mr. Rafferty, before you introduce any exhibits, I would ask that you show them to opposing counsel. You can make them part of the record. I didn't see this hearing as being a full-throated defense, and so I'll give you some leeway, but we're not going to go through the entirety of why you think your client shouldn't have ever been indicted.
I understand that, Your Honor, but I do think it's important because the government has alleged throughout this indictment, as it relates to this particular exhibit, which is in front of the court, that Ms. Powell signed this contract, that it was done by Ms. Powell repeatedly throughout, when their own discovery shows that she did not. It shows right here in the middle of this document that Jim Penrose signed this. And if you look at the contract, it's not even a signature. It's somebody typed her name. So when it says Sidney Powell, somebody typed it. And the person who typed it is James Penrose. So when they allege throughout this indictment that she signed it, that is simply not true. And they had the evidence of that. I didn't. I just found it in the discovery.
Again, when we say they, we mean the GBI, right?
No, I mean the government. This is not within the GBI report. This is other stuff. But again, going back to it, they is anybody on the prosecution team. It doesn't really matter if they can control the GBI or not. You know, we've been asking about special purpose grand jury transcripts. They've turned over Misty Hampton's grand jury transcripts. I've had a chance to look at that. It is in the motion, Your Honor. It does demonstrate Ms. Powell had nothing to do with this and that she authorized this. I have that now. We have the Coffee County group texts, which are also now in discovery. They demonstrate other lawyers, Charles Bundren, Preston Halliburton, all of these people. Ms. Powell had nothing to do with this and that she authorized this. I have that now. We have the Coffee County group texts, which are also now in discovery. They demonstrate other lawyers, Charles Bundren, Preston Halliburton, all of these people, not Sidney Powell, had nothing to do with this.
Well, let's go that route. I want you to list exactly what is it that you think is outstanding that you should have.
Well, if the government says at the beginning, Your Honor, number one, that they have 8 terabytes of discovery, and I have maybe 2, that means there's 6 terabytes of stuff I haven't received. So that's one thing that I'm entitled to. Number 2, Your Honor, since we now know that they have access to the GBI file, what I'm also entitled to is written responses to my requests. That, do you have these materials? And it's not good enough, Your Honor, because we've seen in this case already. It's not good enough, and we've seen it in cases all over this country, frankly, where prosecutors say, I'm aware of my Brady obligations and I will comply. We've all seen that. That's why Rule 5 was amended under the Federal Rules of Criminal Procedure, because that was proven to not be good enough. And throughout the country, there's 3.8 professional rules of conduct about Brady, because Brady is an epidemic. Brady violations are an epidemic because the government doesn't always comply. And so what I'm saying, Your Honor, is when I submit a Brady request, I'm entitled to a response, and a response that's not just, we know what our obligations are, here's your discovery. That's not sufficient. That doesn't satisfy Brady. But Your Honor, I could go on. I've seen Scott Hall's interview. We've listened to it. And what's troubling about that is the same thing. He was told he was authorized. This was just last week he was interviewed. 3 hours. We have 3 hours of recordings where he says, we were authorized. Somebody told me we were authorized. That's what he says. He's asked about Sidney Powell. He never talked to her. Equally important, Your Honor, you hear on the same recording, the government says, we're still trying to figure this out. Well, for Ms. Powell, she's sitting here.
I'm going to object again to talking about evidence that he has. I don't see how evidence that the defense has is subject to any kind of a Brady issue. This is going way outside the bound.
It bleeds into the due process and the motion to dismiss, Your Honor.
Well, let's turn to that then.
So, Your Honor, what I think I've shown is, number one, these bald statements by the government that they've complied are not sufficient, that they need to respond, and they need to respond in writing to the requests I've made. And they need to inquire of the various agencies that have helped with this investigation to find out about the very specific things that I've asked for. And that extends to grand jury and special grand jury transcripts of individuals who testified and who were asked and said in whole or in substance that they've never spoken with Ms. Powell, that she had nothing to do with this. They never emailed her, that she wasn't in a meeting, anything like that. It's not good enough for them to say, we're going to turn over the special purpose grand jury transcripts for the witnesses we're going to call, because that does not satisfy Brady. So they have to answer for those sorts of requests, Your Honor. But more importantly and fundamentally, the motion that I filed lays out all of the different things that shows that the government had, that Ms. Powell was not involved. And it begs the question, how could they possibly have gotten an indictment that is based on evidence and facts if they actually presented the evidence, especially when their own emails and acknowledgments say they didn't even know some of these letters of indentations existed. Ms. Powell's role in this case depends on Coffee County and the idea that this visit was unauthorized when the record now shows it was. But it also shows she was not involved. And if the evidence was presented to this grand jury that she was involved or that it was not authorized, that testimony is necessarily false, and the indictment should be dismissed, Your Honor.
And
that is what I'm
why-
asking for.
And what is the legal authority that this court has to dismiss an indictment based on false testimony before a grand jury?
The legal authority, Your Honor, begins on page 18 of my brief. Okay. The due process clause forbids the government from introducing or failing to correct testimony that it knows or reasonably should know to be false. That's the Napew versus Illinois case, 360 U.S. 264. It goes on, Your Honor, if you go on to page 19, the same principle applies to the state's presentation of evidence to the grand jury. Napew has been extended to grand jury proceedings. In other words, a due process violation ensues when a prosecutor knowingly presents perjured testimony, material in nature, to the grand jury. The state must not force a defendant to stand trial on an indictment which it knows to be based in part upon perjured testimony. And if all of the evidence that I presented, which the
But
government
let me stop you there. So you just read from a Ninth Circuit case. That's not a Georgia case, right?
It's a federal case, Your Honor. I understand that.
So has the Georgia courts ever adopted this holding of the Ninth Circuit?
Your Honor, not that I'm aware of.
Is the 11th Circuit?
Not that I'm aware of.
And I think the 11th Circuit actually explicitly disavowed it. So I just, you're asking me for something that the trial court does not have the authority to do.
Well, I think the court has ultimate authority to oversee this prosecution and make certain rulings based on the evidence that's presented to it. And the evidence that I presented, which is not really responded to at all, is that the grand jury testimony that was presented must have been false, because ultimately the evidence that they had shows she wasn't involved in Coffee County. And to the extent that anybody did something in Coffee County, it was authorized, and they had the evidence of that, and they couldn't possibly have presented it to the grand jury because they claimed to me they didn't even know it existed. So I'm asking the court to use its authority to hold the government to its burden as it relates to Brady, but more importantly, to dismiss this case as to Ms. Powell. I've been saying it from the beginning. I've asked the government to do that. They won't do it. So I'm asking the court. We don't need to sit through a 4-month trial, which they have said, where they know that the evidence is Ms. Powell was not involved in this, and this visit to Coffee County was authorized. I'm going to be sitting at a table for 4 months where everyone in the courtroom, Your Honor does, everyone on the defense team does, the court reporter knows that that's not right, except for this jury. They're going to be sitting here waiting for 4 months. Does that seem like consistent with due process? I submit it's not.
Thank you, Mr. Rafferty. Mr. Wooten.
Judge, I do have a PowerPoint and a couple of exhibits that I'd like
Of
to
course.
have them to give.
What would happen if the subscription ever expired?
I don't know. I don't know. I think there's some up there. Copies. So, Judge, I want to start with a few things. I think we've addressed most of this in our written response. So I'm going to move quickly through the PowerPoint. But before I get there, I want to hit a few points in response to Mr. Rafferty's argument. First of all, we heard a lot about his version of the facts. As we've pointed out in our response to this motion and other motions, this is not the time or the place to argue the facts. That's for 12 people that are going to sit in that box right there. And I guess the court said about 6 alternates. That's who that type of argument needs to be made to. Not the state, not your honor, but to the jury. He said over and over that his client was not involved. He said over and over that there's some letter of authorization that let her do what she wanted to do if she was involved. Once again, completely outside the boundaries for this type of hearing. Those are all things that the state believes it can prove beyond a reasonable doubt that are incorrect. We believe she was involved. We don't believe that there was a letter that granted any kind of lawful authorization, but we'll save that for the jury. Again, Brady doesn't apply to materials that the defense has. And I'll dig a little bit more into that, but we've heard over and over about Brady this, Brady that, and then I learned this from the state. The state gave me this in discovery. I don't see how things that are in the defendant's possession are subject to any kind of a claim whatsoever under Brady. Also, we heard a needle in the haystack argument. The fact is there is a lot of evidence in this case. We did request an 8 terabyte hard drive. That doesn't mean we have 8 terabytes of discovery. We've turned over everything that we do have. And the fact that there's a lot of evidence doesn't mean that we're hiding exculpatory materials in there. That's absolutely not the case. Also, Judge, you asked Mr. Rafferty for the legal authority to dismiss this indictment. And he gave some explanation, which, as the court correctly pointed out, is not controlling law in Georgia. In fact, is kind of the opposite. What he also didn't do was give any evidence to support his claims of misconduct. And so I'm going to jump into the PowerPoint now. And the fact is the defendant's pleadings and his arguments are based on falsehoods. And the state takes these allegations against us very, very seriously. The allegation that we're withholding evidence, suppressing evidence, and that we're committing prosecutorial misconduct are outrageous. They're not true. Number one, the defendant says in her motion, quote, to indict Ms. Powell, the district attorney and special prosecutor necessarily committed prosecutorial misconduct. That is absurd. It's unsupported. The court has heard no evidence other than we don't like the fact that we got indicted. We disagree with the state's theory of the case, and therefore there must have been prosecutorial misconduct. That is not how this works. Number two, quote, Sidney Powell is innocent of all charges alleged in the indictment. Because of this, the state necessarily has possession of significant evidence that exonerates her of all charges. Again, that is absurd and it's unsupported. Same argument. We don't like that she got indicted. We don't agree with the state's case. So there must be something out there that exonerates her. Number three, they say to this day, Ms. Powell has not received any of the documents requested. That is absurd. It's not supported. And frankly, it's a lie. It is absolutely a lie. I'm going to start with that the pleading is avoid speaking demur, and we've responded to some of this in our other responses. A demur that attempts to add facts not otherwise apparent on the face of the indictment presents no question for decision and should never be sustained. Speaking demurs present no legal authority for quashing an indictment. Speaking demurs are void. And this is from State versus Givens, 211 Georgia App 71, 1993 case. Move a little bit into the substance. Again, the pleading raises no cognizable prosecutorial misconduct, and you've heard no evidence of that here today because there was none. A charge of prosecutorial misconduct is a serious charge. It's not to be made lightly, and a defendant who raises that claim has a duty to prove it. And you've seen no evidence, nothing, not one witness. You've seen reference to some emails, again, an argument, speculative argument that there must have been prosecutorial misconduct because defendant doesn't like the outcome, doesn't like that she was indicted. But I guarantee every single defendant that's indicted in this county doesn't like the fact that they were indicted.
Any thoughts on this GBI report that apparently has just come up recently?
Yes, Judge, and I'll touch on that a little bit later in the PowerPoint, but just so the court's aware of the facts there, we became aware of that report last Thursday. The Attorney General's office, that's who was working with the GBI on that investigation. When that investigation began, our special purpose grand jury investigation had been going on for months. And so our investigation was independent of the GBI's investigation. We had witnesses that were subpoenaed to come in and talk about Coffee County. We did not know that they were conducting an investigation. There was some media, reports that there was some sort of an investigation, but the fact is, it was the Attorney General's office that was working with GBI on that. The Attorney General's office let us know on Thursday that they had this case file. I believe the case file was completed and turned over to them on Friday of last week. We picked it up on Monday of this week, and we made it available to the defendants on Tuesday of this week. So I'm not sure how we could move any more quickly than that.
Were there any GBI agents participating in the special purpose grand jury's investigation or at any point in the pretrial proceedings in this case?
Only to the extent that there was one or two that were witnesses to a signature match audit that was going on in Cobb County in late 2020. But that's it. They were not assisting with our investigation. Some of them did come in as fact witnesses, but had nothing to do with Coffee County. Again, I just want to hit very briefly on the fact that the defendant seeks to improperly inquire into grand jury evidence. He says that something about he wants transcripts or wants to look into the evidence that was presented to the indicting grand jury, that he doesn't like the outcome, and therefore there must have been lies told to the grand jury. That's absurd. That's absolutely absurd and not based on any evidence. And as our Supreme Court has held, that when a competent witness is sworn properly and testifies before the grand jury, and where the defendants therefore thereafter found guilty beyond a reasonable doubt, which that has not happened yet here, the sufficiency of the evidence to support the indictment is not open to question. Again, he's shown no evidence of prosecutorial misconduct because there was none. Defendant's false claim that because she was indicted and because she maintains her innocence, that the state must have misrepresented evidence and suborned perjury is, one, unsupported by evidence. Two, it's offensive and it's inappropriate given the serious nature of this type of allegation. And three, it's a frivolous use of the court's time. I'm going to move into the Brady motion. Essentially, Judge, the defendant seeks things that are not Brady material. And to quote our case law, to prevail on a Brady claim, one must show that the state possessed favorable evidence, that the defendant did not possess that evidence or could not obtain it with any reasonable degree of diligence, that the prosecution suppressed it, and that there's a reasonable probability that the outcome of a proceeding would have been different. That's coming from Waldrop v. Head, 279 Georgia 826, a 2005 case. And so I want to stop here for a second and address some of the arguments that were made. We received this list of, I think it was 30 in the letter and 37 in the motion, categories of evidence that Mr. Rafferty believes exists. We have told him that those things don't exist. We can't make evidence appear out of thin air. We're not responsible for turning over things that we do not have. The court knows that. And again, I'm just making a record here, but we can't be made to turn over things that either don't exist or that we don't have. We've turned over.
Define we for this case.
Judge, as the court kind of alluded to, we don't believe that GBI is under our authority here. This was an independent investigation of the Fulton County District Attorney's Office. There's no law enforcement agency that was a partner agency with us here. And so we believe that it's kind of limited to the Fulton County District Attorney's Office. There's a few areas where that might expand a little bit. There was some evidence that was obtained with regard to the Ruby Freeman incident out of Cobb County. Certainly anything that Cobb County has, I think we have a responsibility to get and turn over, and we've done that. Certainly anything the GBI has as it relates to what they gave to us, we have a responsibility to get it and turn it over, and we've done that.
Are there any other law enforcement entities, either in Georgia or nationwide, that you've identified or made requests to, or that you're trying to get their materials?
No.
And what's the one in Cobb County? Was that the sheriff's office?
Cobb County Police Department.
Police Department. All right.
Yes, sir. And again, we've received that complete case file and we've turned it over. I also want to talk about, Judge, like I said, what we have turned over, and these have been provided to the defense. They were also attachments to our response. We turned over our first batch of discovery, as the court I'm sure remembers, in open court. I believe that was September the 14th of 2023. We turned over a second batch on September the 20th of 2023. third batch on September the 26th of 2023. So we have turned it over on an ongoing basis. We're not holding anything back. We're not hiding anything. Again, I realize this is very small, but this is one of the emails that I believe Mr. Rafferty put up related to this purported letter of authorization or letter of invitation. Again, as we pointed out in our response, we don't believe that this purported letter proves what Mr. Rafferty believes it proves. But when it was requested from us, we looked at our materials to see if we had it. We did not have it. We said, please give us the media story that you're saying references it so we can make sure. We took a look at the media story. Again, we said, we do not have it. We don't have what you're talking about. So we could not turn it over. It's not Brady material. Additionally, like I said, and this is what I referenced, this is an email showing that when we received the GBI materials on Monday, we immediately made them available to Mr. Rafferty. We're not hiding them. We're not holding anything back. We got it from the AG's office, immediately started copying it, and turned it over. Again, like we talked about, we don't believe that our Brady requirements are imputed to agencies that we have no authority over. I know that the court's familiar with that case law. Additionally, one more exhibit showing that we, as recently as 12/20 today, turned over some special purpose grand jury transcripts that we received yesterday and today. So as soon as this is coming into us, we are turning it over. Additionally, the defendant's Brady motion seeks non-discoverable attorney work product. He asked for things like our notes, like logistical scheduling communications, and we've listed kind of some of those things in our written response. But as our courts have held, attorney's work product is generally non-discoverable, non-exculpatory information, and an attorney's work product does not become discoverable simply because the opposing attorneys might find it strategically useful. Foster versus the state, 258, Georgia 736. Since much of a prosecutor's work product will not fit the definition of exculpatory evidence subject to discovery, only that's actually exculpatory must be turned over, and we have done that. That's Waldrop versus Head, 279, Georgia 826, a 2005 case. And Judge, I can't let this go. The defendant in his motion made false representations to this court. He requested, and again, this is going back to this letter of invitation, any and all evidence regarding a written letter of invitation from Coffee County officials, leadership, or representatives, Catherine Price, Rudolph Giuliani, or others granting authorization to examine voting machines. Where I kind of let off was the requirements for a Brady claim. First is that the state has it. Second is that the defendant doesn't have it. So in categorizing something as Brady material, the defense is essentially saying, we don't have it. We're entitled to it and we don't have it. And the day that this motion was filed, another motion was filed by the defendant, same day that attached the purported letter as an exhibit. So if the defendant had it in his possession and is saying that he doesn't have it, that it's Brady material that the state needs to turn over, that's a serious problem. Defendant has shown no evidence of a Brady violation. His false claim that because, or her false, Ms. Powell's false claim that because she maintains her innocent, the state must possess exculpatory evidence. It's unsupported by any evidence. It's a willful misrepresentation of the fact that the state has turned over all of the exculpatory evidence in its possession. That's all I have, Judge, unless you have any questions.
Yeah, I want to explore the needle in a haystack authority, if you've had the ability to look into that. Essentially, if you have any thoughts about document dumps in criminal cases. We don't deal with that in all of our cases. Usually it's a little bit more manageable, but, and I don't know if, I think Mr. Rafferty actually has shown that he's not afraid of the haystack. I don't know if, I think he's found all the needles as they exist, but regardless, what's the,
I don't know that I found all the
we'll get there.
There's probably more. I'll just keep looking.
All right. So what to that end? Because essentially what I'm trying to figure out here is what is it exactly that I'm expected to do with this, in terms of the Brady obligations or the purported ones. Essentially, it seems like Mr. Rafferty is asking for, in effect, kind of civil interrogatories and wanting you to be able to respond to each one of them. So that's what I kind of want to put to you is what's your position on that? And to what extent does the state have an obligation to point to things within the 2 terabytes of data?
Sure, Judge. I mean, I don't.
What legal authority suggests it one way or another?
I don't have those cases in front of me, so I could provide a written response if the court wants to, but that would actually cite to authority. But I can say the state's position is that we don't have to like say, hey, here's the folder of all of our worst evidence or all of your best evidence. That doesn't make any sense. We've turned over all this evidence in an organized fashion. It's not like it's one folder that has, 50,000 documents that have no titles or description or anything like that. It's organized in such a way that Mr. Rafferty can go in and find the Coffee County stuff. And so I don't think we have an obligation to narrow it down any more than what's a reasonable organization. I don't think we need to say like, hey, these are, our 5 worst facts. Here you go. Good luck with your case. I just don't think that that's the case, Judge. That's our position. And again, if Mr. Rafferty wants to give the court some specifics as to how it's too difficult for him to filter through the way that we've turned it over, I think it's his burden to show that. I mean, I don't know what's difficult about finding the discovery because he hasn't said specifically what the challenge is.
I'll say it now, Your Honor. There are folders that say Coffee County, and there's a